normally, after talking with your clerk, I thought it was appropriate I just go ahead and file a quick written motion regarding the basis for our request for the adjournment.
And it was my understanding as of yesterday that there was a stipulation to adjourn based on the facts that...
That was, I think, a misunderstanding. There was no stipulation. It was always my understanding that the defense intended to object to an adjournment and possibly request a dismissal. And to give the court an update with regards to the complaining victim, he was released, so he's not in the hospital at this point in time, but he did have surgery Wednesday morning. He is on bed rest for a 2-week period. For that, he is also medicated on narcotics at this time due to pain medications.
Well, I think under those circumstances, it's not that the prosecution is trying to delay the proceedings. You have a necessary witness who is unavailable because of the surgery, the alleged victim in this case. I am going to find good cause to adjourn the preliminary examination. We're going to have to pick another date. It has to be on a special day where I can designate a full day for this. Christy, July 18th. My clerk has determined that Friday is available for me. So we will reconvene on this matter on July 18th at 8 a.m. And I want to let both sides know, I don't know what time you got here today. When I say 8 o'clock, I'm picking a special date for you. 8 o'clock means 8 o'clock. And you might...
We were both here.
Okay, Mr. Upshaw is not here.
Correct.
And I guess he's the next person I'm going to talk to. But I just wanted everyone to know, when I say 8 o'clock, I get started at 8 o'clock. As long as the prisoners are brought over, we'll get started right away. So keep that in mind going forward. And we'll see you on July 18th at 8 a.m. on the motion to adjourn.
Your Honor, may I speak?
You may.
First of all, the defendant, I know you made your ruling, but I do have to object to this. We have not received, I've worked with Mr. Newman for a long time, and I know he's a person of utmost integrity, but we have not received anything regarding this essential witness's medical surgery, a report saying he is in surgery, what kind of medications he's on, to say that he couldn't testify today via Zoom hearing or anything. I know that's what Assistant Prosecutor Newman said, but we haven't received anything.
I'm going to let you finish, but I just want you to know it doesn't work with the Zoom in this court. So
that's fine.
I just wanted to...
Yeah, but even in person, if he's at home, Mr. Taylor, my client, has been in custody now for over 30 days. He's 21 years old. He has no criminal history, public criminal history, Your Honor. He's had a son, Kamazi Taylor, who was born May 13th. He has not even seen his son. He's being charged with a CCW and tampering with evidence, which frankly I don't even understand how that is possible, considering he was defending himself from people in an incident which he was getting beat down by 3 people that were pistol whipping him with a gun, and yet he's being charged with tampering with evidence. With that said, though, Your Honor, he doesn't have a criminal history. He's been in custody for 30 days. This is being adjourned for good cause because people cannot proceed and bring their witnesses to court today. We just got a medical examiner's report. I've not reviewed yet. I've not even looked at it. We've been waiting for 30 days. I'm asking, Judge, that Mr. Taylor be released on some type of bond, personal bond, with a tether, so that he can go to his job. He's got a roofing job that he can go to tomorrow if he gets out. If you want to put him on a tether, that's fine. But he's charged with tampering with evidence. He did not possess a gun that day. He was defending himself, trying to pull a gun out of somebody's hand that came at him with a gun. And he's been in custody for 30 days, and he had a son that was born. I think it's for adjournment that's based on the people's request. Defendants has been ready to go at exam now for a month. I'd ask, Your Honor, to humbly provide some type of tether bond bond reduction so that Mr. Taylor can go meet his son, provide for his family, and go to work.
Mr. Newman, your response?
The people would object for the record, and I'm not gonna get into his record, but, because it is non-public, but, there is, prior, issues, I think that the court probably has access to. I think the bond is reasonable in light of the circumstances, so we would object and leave it to the court.
And Mr. Miller, the last time that you were here, we made a referral to Community Corrections for a report. That report has not yet been made. Sir, have you been seen by Community Corrections yet?
Yes, but it was before my last court date. I haven't been seen after.
Okay. So it would be somebody from Community Corrections. So, Mr. Miller, as it stands, the court believes that the bond is appropriately set. The charges are tampering with evidence, a 10-year felony, larceny of a firearm, carrying a concealed weapon, and larceny less than $200. So there are additional charges that we did not mention, but the court is not going to modify the bond at this time. We do not have a report as of yet. You may want to check with Community Corrections to make sure that somebody comes out and sees him, but I am not going to reduce the bond. Your bond motion is respectfully denied. If you step to the side, you'll get your notice for July 18th, and then that concludes this matter. I know that we were keeping the defendants apart, and they were coming in separate vans, correct? And the van that's bringing the co-defendant got an emergency call. Oh, you what? Okay. So that concludes this matter. We will handle the co-defendant as soon as Mr. Upshaw gets here.
Judge, I would ask too that we get some kind of confirmation and notice of the survey that took place yesterday that left, that's the reason for this adjournment.
Well, there's HIPAA issues. You can both use the issue, and I will make a determination. Okay?
Thank you.
All right, that concludes this matter for today. And Mr. Newman, please let me know as soon as Mr. Upshaw is here so we can handle the co-defendant. She's here?
Certainly.
I don't know that her attorney's here.
Okay, thank you.
All right.
That was good.
Judge, may I approach?
do the judge a favor.
You want me to approach?
No, I need you to see if Mr. Newman has found the other defense attorney. Oh, okay. No, you know what? You're good. You're off the hook.
Okay, fine. Thank you, Judge.
Well, since we're waiting, I will take Judge Costa's docket. Let me see if they have some files available. Calling file number 25EA01416, People versus Alejandro Salazar.
Good morning, Your Honor. James Hiller appearing on behalf of Mr. Salazar. Judge, I'm standing in for the attorney of record, Richard Cervinac, this morning. Sir, can you state your name, please?
Alejandro Salazar.
And sir, you're here today for pre-trial on the charge.
Good morning, Your Honor. Corey Newman on behalf of the people.
And Randall Upshaw on behalf of Ms. Taylor. State your name, Ms. Taylor.
Lakylia Taylor.
Ma'am, please rise. Your name, please?
Lakylia Sheila Taylor.
Very good, and you're here today for a date certain preliminary examination. This was a special date that was set by the court. The court is in receipt of a motion to adjourn preliminary examination. The court has already made a record as to co-defendant Dejuan Taylor. The preliminary examination was to be held jointly. The record should reflect that the motion to adjourn preliminary examination indicated that the complaining witness, Dejuan Morris Turner, an essential witness at the time, had surgery yesterday morning for the injuries result of the shooting and was unavailable due to bed rest and pain medications while recovering. Further, the medical examiner's report finally has been prepared. I want to make sure defense counsel has an opportunity to review that. Mr. Miller had indicated that he hasn't even had a chance to review it because it was just tendered to everybody. So I found good cause as to Dejuan Taylor. Mr. Upshaw, I don't know that there's, I mean, if you want to make a record, you may make a record, but I did find good cause to adjourn the preliminary exam, and the date we picked was July 18th at 8 a.m.
Just for the record, Your Honor, I am aware of the date at 8 a.m. on the 17th. And just so Ms. Taylor knows and family knows, I did not consent to the adjournment. The prosecutor asked for adjournment. Somehow it happens, but I understand that, Judge. For the record, it's beyond her 21-day rule, and I object. Thank you.
Thank you. And then, Mr. Upshaw, you have a bond motion that you filed.
Yes, Your Honor.
You may argue the bond motion and make a record. The bond motion that you have presented to the court sets forth the same arguments that you made on May 20th of 2025. I referred this matter to Community Corrections. There is no updated report, and I don't know what has changed other than we have a new date that would warrant the court at this point reducing the bond. I denied the bond reduction based on the same set of facts that you presented to the court today. What would you like to say?
Judge, I totally respect the seriousness of the offense. I'm asking the court, especially due to the amount of time that's been passed because of things beyond the court's control. Mr. Kumar and I both, and this is pretty much, I don't want to take the court's time, but it's pretty much the same thing, but I just ask you to put emphasis on the fact that here's a woman with absolutely no prior arrest. And it's undisputed that the only reason she was there was taking her brother allegedly to the Foot Locker. And Judge, I don't want to make the same argument, but we're going to leave her in bond when, in my opinion, if you would have seen the video, everyone knows she was not the aggressor.
And Mr. Upshaw, we will see the video, I assume, during the preliminary examination. I am going to respectfully deny your bond request at this time. I found good cause to adjourn the preliminary examination. We are coming back on July 18th. And I'll see everybody at that date and time.
Have a good day, Your Honor.